welcome. Welcome to our program on the Unpacking the Aspergillus lawsuit. My name is Kevin Jacoby. I'm the owner of Jacoby Law, and I was the chief lawyer on the Aspergillus lawsuit here in Oregon. With me today is Mike Getlin. Mike, go ahead and introduce yourself. Mike, you there?
Hi, coming through? Am I coming through okay there?
Yes.
Great. Yeah, thanks a lot for putting me on. I'm gonna give my apologies to everybody for not being on screen. I made a scheduling mistake this morning, and I'm doing my best to cover. So we'll see what we can do.
All right. And go ahead and introduce yourself, Mike. Uh,
Of Oregon, I have been working in. I've been a licensee in Oregon since 2016, and touched all corners of the industry, and jokingly say I've failed at most jobs in cannabis at one point or another. But yeah, and back in 2019, we started the work to merge the trade associations in Oregon, all the four of which coming together created Cannabis Industry Alliance, officially finalized last year, and we've had the pleasure of working closely with Jacoby Law to try and use the courts as a tool to better the business climate for our licensees.
All right. So, thanks, Mike. So today, Mike and I are going to be discussing Oregon's Aspergillus testing rules for cannabis and the CIAO and other industry actors' efforts to fight back. Feel free to post any questions that you have in the chat, and we will get to them at the end of the program. So, to start things off, so what is Aspergillus? Now, if you signed up for this program, you probably already know what Aspergillus is, so we're not going to spend a whole lot of time on that. But in a nutshell, Aspergillus is a very common fungus that and that in some certain populations causes a condition called aspergillosis. The rates of invasive aspergillosis are very minimal, limited to populations that are immune compromised, already have severe lung infections, or are undergoing chemotherapy, that kind of stuff. So the bottom line is you only need to worry about aspergillosis if you are severely immune compromised. So that begs the question, why are regulators requiring testing for Aspergillus in cannabis? And there's a couple of reasons for that. So first of all, there's regulators are under intense lobbying efforts by the companies who develop and manufacture the testing kits. They have an interest in overhyping the risk of Aspergillus in cannabis because they make money selling the testing kits to the labs. We here in Oregon, we found evidence of this through public records requests to the Oregon Health Authority. Also, the companies who sell the remediation or mitigation solutions to the producers have a vested interest in Aspergillus testing. And also another reason why you've got regulators requiring testing for Aspergillus is because of the regulatory bias against inhalation of any substance or product that regulators consider a vice. Think tobacco and nicotine vape products. And Mike, I think you've got something to add here. All right. Mike, are you there? All right, looks like we lost Mike. But in any event, there's also a host of bad studies out there. So I call them pseudoscientific studies, of which are quite dated. Um, that those with vested interests against cannabis have cited to suggest that the cannabis consuming population is more likely to be immunocompromised and therefore more likely to be susceptible to invasive aspergillosis. Um, so one of those studies, now more than a decade old, which would be before the prevalence of adult use legalization, and it's likely relics of a medical-only legalization regime. So in particular, one claim that was made by OLCC in a press release where they were recalling products for Aspergillus contamination, they cited a study for the proposition that, quote, recent research has found that fungal infections, nearly half of which were attributable to aspergillosis, are 3.5 times more likely in cannabis users. But the study they cited didn't support that statement. The study involved a statistical analysis of a health insurance claim database in 2016 and stated that the study itself stated it was not possible to determine the source of infection, of the Aspergillus infection, cautioning that any number of factors could contribute to the correlation. Um, so that study established only that in one insurer database in 2016, self-identified cannabis users were more likely to be immune compromised than non-cannabis users, which the study authors themselves noted was likely a remnant of medical marijuana only regimes. In other words, when only people who have qualifying medical conditions are legally allowed to possess and use and consume cannabis, of course, self-identified cannabis users are going to skew immune compromised. The study also did not differentiate between the method of delivery. So self-identified immune compromised cannabis users who had an aspergillosis diagnosis could have exclusively ingested cannabis via edibles, which means they did not get aspergillosis from smoking cannabis. They more likely just got it from breathing it in the air in the environment. I see, Mike, are you back on? Nope. Okay.
Yeah, I'm here, Kevin. I'm sorry. I am having a heck of a time finding a spot with service, but I think I've got it.
All right. So just wanted to circle back to the regulatory bias against inhalation. Do you have anything to add on that point?
Yeah, I think, what we have observed over time is that, there are kind of three paces of change in the cannabis world. The business world changes quickly, the science lags behind it, and then regulatory changes lag far, far behind that. And so, we still live in a world where the voices from other interested parties, such as public health and public safety, are heard much louder by regulators than the voice of business owners. Now, in more mature markets, alcohol, even tobacco, for example, obviously infinitely more dangerous to public health than cannabis. A balance has been achieved over time, with both sides kind of fighting for the narrative of what is the proper balance between public health and safety and the success of an industry. Unfortunately for cannabis, our experience in working with the Oregon legislature and others, for that matter, is that we have to shout 10 times as loud as a public health official to get the same attention. And read, we have to spend 10 times as much money. So we've run into this paradigm over and over again where you still have very powerful groups that, frankly, are looking for confirmation bias that this stuff is, frankly, more dangerous than the science actually shows that it is. And so, for this case, especially in Oregon, I'm going to go back a few years when we had the electronic vaping illness crisis. If you guys remember all of that, I sat in on a work group for the governor, Kate Brown, at that time, and I listened to a director at OHA say quite literally, well, something to the effect of, you know, this might be an overreaction, but if it gets one step closer to banning all smoking of all things in Oregon, then that's a win for OHA. So, you're in an environment where we are batting from way behind in the count, and it's hard to play catch up.
Yeah. Thanks, Mike. So, and then final point on this or on this topic is that Aspergillus testing is not required for any other agricultural product. So Mike, any thoughts as to why that is?
Well, yeah, and again, like I said, most other agricultural products, there are two reasons for that. Most agricultural industries have gone through the process of fencing with regulators to reach that balance between profitability and public safety. We have not done that yet. You've had lawsuits back and forth between Monsanto and regulators for the better part of a century, right? Not to lump us in with those guys, but to the point being, we just haven't achieved that balance yet, and we don't have a credible political threat yet to counterbalance overreach by regulators. And then the other reason is that people don't, public health officials don't view food as an evil to be scoured out of society like they do with cannabis. And not all public health officials feel that way, but I would say a meaningful majority of them do. And so if they can use faux science essentially to try and try and accomplish their health goals, they will quietly go along and not ask too many questions. And I think that's exactly what happened in Oregon.
Yeah. Um, and we do have a couple of questions and comments from one of our participants. So one comment: we should conduct a meta-analysis of all the studies put forth by the scientific supply companies, and further comment that a meta-analysis that can factor out biases, including funding sources, et cetera, and validate the studies. I think that's a great point. There are a lot of talking points out there that originate from those with a vested interest in rigorous testing standards like this, that are misleading. The use of the use of misleading statistics, or the correlation does not equal causation kind of thing. So, and another comment is that there's one Aspergillus study that claimed a person died from aspergillosis, but the coroner report has the cause of death listed as unknown. So there's lots of examples of that in these studies where there's a presumed causal link that is being advanced in these arguments that the studies themselves don't show. So it's a lot of this is being able to read these studies with a critical eye and pick apart when are not looking at these carefully, and they're just looking at the hype. So let's move on. Let's talk about Oregon's Aspergillus testing rule. So it went into effect in March 1st of 2023. We had about a year of lead time before the requirement went into effect. That is where we knew it was coming, and it was there was a lot of questions about how it was going to impact folks. The bottom line is, though, without getting into too much detail, is Oregon's Aspergillus testing rule was zero tolerance, and by zero tolerance, it was a DNA test that tested for the presence or absence of Aspergillus DNA in a sample, and if there was any presence detected, meaning any errant strand of DNA, whether alive or dead, that produced a negative result. Um, a narrative came up where this was about, this rule was about trying to get rid of moldy weed out of the system. That was just an incorrect narrative. This was not about getting moldy weed out of the system. There were other tests that covered presence of mold or the toxins that uh, uh, other toxins that come from moldy weed. So, and Mike, can you talk a little bit about uh, when this rule came out, how the industry reacted?
Well, this rule came out at a time in which the industry had a relatively stable relationship with the Oregon Liquor and Cannabis Commission. And at the time, the CIAO's leadership requested a meeting with a couple of director level staff at the OLCC to discuss our concerns about this, because we were starting to see alarming failure rates on the handful of R&D tests that were being done. At the time, it was about March, I believe, of 23. No, I'm sorry. It was it was in the spring, and we started to talk to the OLCC about major concerns of basically having the entire industry fall off of an economic cliff, because the outdoor crop, we were seeing signs of more than a 50% failure rate on R&Ds. Anecdotal small data batches. So we talked to the OLCC. They kind of refused to believe that there was a problem. They were saying failure rates for compliance tests were in the single digits. And so they kind of dug their heels in and didn't believe us. So what we got to in that conversation essentially was that we were going to, at their request, begin R&D testing samples from the previous year's outdoor harvests, which we knew, we knew were going to be more representative of the upcoming outdoor harvest. At the time, the OLCC had made clear that their rule only applied to stuff harvested later, and that R&D testing of
On or after March
those,
1st.
yeah, on or after March 1st, thank you. So R&D testing of previously harvested products would not lead to recalls or failures for compliance testing. So we asked CIAO's membership, and myself in my role with Nectar, all of our outdoor farms from the previous year, we started R&D test everything. And subsequently, the OLCC, when they saw samples that were going to market that had failed for Aspergillus, even under an R&D test, even samples that were from crops that were not subject to this testing regimen, they did a massive recall of about 40,000 packages, as I recall, across the state, affecting a number of companies. And it was such a breach of trust, since we had done this R&D testing at their request and with their promise of no negative consequences, that really was an eye-opener for us. And we started to realize that, when it comes to this specific argument, we didn't have any friends either in the legislature or in the regulatory agency. And so CIO, along with a handful of small producers, just saddled up and hired Kevin, and the rest is your story to tell.
Yeah, well, and just another point about that OLCC recall. In the press release announcing the recall, OLCC declared Aspergillus a contaminant. Now let's back up a little bit. Aspergillus is everywhere. Aspergillus is in all indoor and outdoor air environments. It is impossible to get Aspergillus out of any of such environments. It is possible in controlled air environments, but it's almost impossible to keep it out.
Even hospitals, for example, was one of the things that we looked at, right?
Yeah. So if OLCC is declaring Aspergillus a contaminant, well, then the air that we are breathing right now is contaminated. So in essence, what this Aspergillus testing rule required was that cannabis be cleaner than air. And it's literally an impossible standard to meet. And then I think one statistic that we found, based on the state's own data, was that 38% of producers who submitted samples for Aspergillus testing reported at least one failed test. So, and that was all before the outdoor crop was even available for testing, had even been harvested. So, so the recall happened in June of 2023. That that, as Mike said, that kind of lit a fire under the CIAO membership to do something, and that's when we started to get a critical mass of folks willing to step up and be, and supply the evidence necessary in order to file a lawsuit. So let's talk about the rule challenge. So on July 28th of 2023, CIAO, as the lead chief petitioner, along with other petitioners, submitted a petition to the Oregon Court of Appeals to declare the Aspergillus testing rule invalid. In Oregon, the Court of Appeals is where rule challenges are determined in the first instance. In connection with that petition, we also submitted a motion to stay enforcement of the rule pending judicial review, citing irreparable harm to the industry and a likelihood of success on the merits. It's somewhat like a preliminary injunction. And because a judicial review proceeding proceeds as a normal appeal, so that can take a year to 2 years to work its way through. This motion was the vehicle for us to say, hey, we've got we have a likelihood of success on the merits, and we have a showing of irreparable harm. So, and with regard to the legal argument on the likelihood of success on the merits hinged on this statute, which is found in ORS 475C, that states that OHA, which is the body that promulgates cannabis testing standards, it says OHA may not adopt rules that are more restrictive than reasonably necessary to protect the public health and safety. In promulgating their rule, this Aspergillus testing rule, OHA examined testing regimes in 8 other states. This is according to their rulemaking record, including Colorado, Arizona, Washington, California, Nevada, Ohio, Maryland, and New York. OHA stated in their rulemaking materials that the vast majority of states had an Aspergillus testing rule similar to what they promulgated. That wasn't true. Only half of them did. Washington, Ohio, at the time, Washington, Ohio, Maryland, did not require testing for the presence of Aspergillus at all. And while Arizona does require a test for Aspergillus, it's not zero tolerance. It allowed for the presence of Aspergillus of spores equal to or less than 1 colony forming unit. In other words, if your Aspergillus can't grow, then it passes. So our argument was that OHA had failed to explain why the 3 states who didn't test for Aspergillus at all, or the 1 state, Arizona, who allowed for some tolerance level, were not adequately protecting the health and safety of their citizens. So ultimately, that argument won the day in the results. So on August 25th, 2023, the Court of Appeals issued its order granting our motion for stay. They found that OHA had, quote, not raised a clear response to petitioner's contention that OHA does not appear have to considered whether there were less restrictive alternatives to the rule it adopted, and or determined that less restricted alternatives that were in the record in the form of lesser testing requirements in other states surveyed by OHA would adequately protect public health and safety. The court went on to state, given the legislature's clear directive that rules adopted by OHA establishing standards for testing marijuana and identifying appropriate tests for biological contaminants to protect public health and safety may not be more restrictive than reasonably necessary, the court is persuaded that petitioners have showed a likelihood of success on judicial review sufficient to weigh in favor of a stay in this case. So, in essence, we won. We won on primarily on the legal argument, but not only on the legal argument, on our evidence that we had on our evidence that the industry was facing an existential crisis and about to suffer irreparable harm from this rule. Following this ruling, OHA repealed the Aspergillus testing rule, first on a temporary basis and then on a permanent basis. So once they permanently repealed the Aspergillus testing rule, that mooted the underlying petition for judicial review of the rule, so that the case was ultimately dismissed, with the petitioners being the prevailing party. So since then we're now a year beyond that, that OHA throwing in the towel, and it does not appear that OHA has taken any steps to revisit the issue of Aspergillus testing, or start over again. So however, that leads us into our next topic, looking ahead. I think the first issue is for looking ahead is just to make sure everybody is aware that the American Society for Testing and Materials is currently putting together work groups to establish uniform standards for cannabis testing. So that it is they're currently organizing the panels. Mike, do you want to speak to that a little bit?
Yeah, sure. Thanks, Kevin. So, ASTM is a group that essentially is made up of private citizens and interested parties, and they create, a series of essentially recommendations, which are then typically utilized by various regulatory agencies to come up with, testing standards and a whole bunch of other stuff in a whole bunch of industries. But, we started to identify the need to have more of a voice in those circles because with, coming changes to the federal landscape, it's no mystery that a lot of state officials are going to be, and the feds are going to be looking to ASTM standards to promulgate rules for this stuff. And so we've begun a process of trying, frankly, to implant as many cannabis licensees within the ASTM subcommittees that are dealing with cannabis-related issues as we can. And it is an uphill battle because those agencies or those groups tend to be primarily staffed by auxiliary support companies that sell testing machines or remediation equipment, stuff like that. So we've begun that process. I think we've got about 25 or 30 members from CIAO that have joined those subcommittees and are beginning that work. But again, it's a big elephant to eat one bite at a time for us. But you got to start somewhere.
Mm-hmm. And yeah, so if you're not a member, you can sign up, and we can give you more information later on that. What does this mean for other states? So I will, well, before I jump into this, I am an Oregon lawyer. I'm only an Oregon lawyer. I'm not a lawyer in any other state. So take this next information with a grain of salt. But from what I can see, most states have a provision in their statutes that authorize their agencies to promulgate cannabis testing rules that are similar to Oregon's, that require some measure of restraint from overregulation. For an example, I've got the California Business and Professional Code quoted here on the slide. So that code that section deals specifically with cannabis testing rules. And it states regulations issued under this division shall be necessary to achieve the purposes of this division based on best available evidence and shall mandate only commercially feasible procedures, technology, or other requirements, and shall not unreasonably restrain or inhibit the development of alternative procedures or technology to achieve the same substantive requirements. Nor shall the regulations make compliance so onerous that the operation under a cannabis license is not worthy of being carried out in practice by a reasonably prudent business person. I would argue that this is actually a much stronger regulation or much stronger statutory language than we had in Oregon. So there is at least an argument in California to fight back against their cannabis Aspergillus testing regime as well. And again, I didn't look at other states, but I would imagine most states have something similar that a prudent or a savvy lawyer could hang their hat on in order to challenge these regulations. So given the prevalence of Aspergillus and the science about its limited risk to healthy individuals, I would venture to guess that these regulations in other states are susceptible to similar legal challenges. And another thing to keep in mind is that many of these advocates for these stricter testing requirements are looking at other possible contaminants or I say contaminants in scare quotes, to test for and raise a panic about. So this fight is likely to continue on other fronts. But our most important takeaway is that industry advocates need to be focused on investing in educating legislatures and regulators. Mike, do you want to add to that?
Sorry, my mute button keeps getting stuck on me. Yes, and I think that the only thing I would add to that is, my experience as a licensee for, gosh, the better part of 10 years now. I think many of us, especially that got into it early, still have a little bit of a hangover from a mentality where we felt so lucky just to be able to legally sell the stuff that we were kind of willing to subject ourselves to whatever overregulation the state saw it necessary, thinking that it was a temporary reality. What we have come to find is that if you look at any other mature industry, there are decades of legal battles that have created the tracks on which standard regulatory changes are kind of driven along. And we haven't gone through that process yet. It is not a betrayal of the system. It is, frankly, the heart of the American business and legal system. And business cannot operate without utilizing the courts to hold regulators accountable for the proper balance between business interests and public safety and health. I think the other important thing to remember is that as these markets mature, every month that goes by, the government relies more and more on the tax revenue we generate. I think that my personal opinion is that Governor Newsom in California, for example, is not attacking hemp-derived intoxicants from the fondness of his heart. He's looking at a declining industry and rapidly troubled tax revenue, which we're seeing across mature markets. And so, I think that the time has come for us all collectively as business owners to act more aggressively in these situations. And if we are too scared to cross swords with regulators in the courts, we will continue to labor under nearly impossible regulatory conditions, and they will not be the ones that suffer as a result.
Great point. So, yeah, having a I think the other piece to this is to be vigilant when be vigilant of proposed regulations, particularly around testing standards, but just in general. Um, take get involved, participate with the various agencies. In Oregon, we've got three main agencies that regulate cannabis. It's OLCC, OHA, and Department of Agriculture. Um, so keep an eye out if you don't pay attention, some of these regulations can slip under the rug without notice and with very little notice. And that's not to say that it's not that you can't fight in court, but you're better off to try to fight before the rule goes into effect. Um, Mike, before we move on, I want to I want to circle back to when the Aspergillus testing rule was first promulgated. Did that go through the rules advisory committee
Oh,
process?
that's a good question, Kevin. I would have to go back and reference our notes on that. Um, I think, and the reason that that's not fresh in my mind is that our experience with the rulemaking process in Oregon is that it tends to be a rubber stamp. And personally, I've sat on, gosh, I think 9 rules advisory committees over the years, and I've never seen an industry recommendation taken seriously.
Mm.
Um, so I don't really remember the answer to that, but I think more importantly, that's not, at least in Oregon, that's not where the rubber meets the road.
Right. Well, and I think that's part of the thing is, if industry is going to participate in the rulemaking process, which it is required to do, they have to at least solicit the input. Agencies are going to take industry concerns more seriously after they've learned a lesson that when they don't, they get sued and they get their hands slapped by the court. So it is a mutually, these litigation options do have give us some weight in future fights. And uh so I'd say, the fact that we've fought this fight and won makes it more likely that um we're going to be taken seriously when we're at the table in future fights. So, um, all right, now we can open it up for questions, and it looks like we've got a question from Darren. Tony, can you go ahead and give him a
Okay. Hey, thanks. First of all, thanks for putting this on. It's great, very
yeah.
informative. I appreciate your guys' ability to stick to it and put the fight up and pass the word to other states. We have operators here. I think we have the financial means of putting the case forward. Although we haven't been able to yet to find an attorney. We have an attorney that's a willing participant, but maybe they just don't have um, quite the gusto that you guys do. And one of their concerns is that the rule has been in effect for since 2018. Call it 5.5, 6 years, and they think that it would just be very hard to get a court to say, okay, this rule should have never been in place. So like maybe let's back it out. And I think that's one of the problems now. I told them, but it wasn't until recently that the regulators started doing recalls. The qPCR technology is obviously, as you guys know, it's a joke. And so one of the angles was to try and prove that the PCR technology is faulty and it shouldn't be used for recalls, and that's overly burdensome, which would mean that the only way to really identify the Aspergillus is with a trained microbiologist. There's very few of them around, and possibly we can just get the whole thing thrown out. What would be your angle of attack, being that you already stated that you think that our business and profession code actually has a more strict determination of overly burdensome regulations, or what would be determined an overly burdensome regulation? Should we just look for another legal champion, or is there a way to like maybe coax our attorneys into actually just going for it and
Yeah.
putting forth a lawsuit regardless?
Well, I think thanks, Darren. Yeah, it is difficult, and I'm not a California practitioner, so there's probably some nuances that an experienced California administrative law litigator would know that maybe I don't. But my read of the professional code, I've got it back up here, um, is is that, you know, there seems to be a lot of grist for the mill in that statute. You know, is a zero tolerance testing regime commercially feasible? Probably not, given the science behind Aspergillus, the prevalence of it. And does having a zero tolerance standard for Aspergillus, does it unreasonably restrain does it unreasonably restrain, or does it make compliance so onerous? I would argue that it does. I think the evidence is there, given all of the recalls that have been going on. So you know, the argument that the science of Aspergillus is that it's everywhere. And you know, just because you know, a spore of Aspergillus might land on a sample before testing doesn't mean that you know, that doesn't have anything to do with the growing method. It doesn't have anything to do with the product. It's just the fact that the product moves through the air, the ambient air at some point. So I you know, I think there's lots of avenues for attack, but the difficulty in California is that it's only been recently and rigorously enforced, as is my understanding. Is that in the, you know, since I think it's been around since about 2018, but there have been workarounds and ways to get through it. But now the BCC is kind of going overboard in enforcement. Is that, am I off base there, Darren?
No, that's absolutely correct.
Okay. So my recommendation is to find somebody that is that is experienced with particularly in administrative law in California, state level administrative law.
So Darren, Mike here. And this is a total long shot, but I have worked with an attorney out of San Diego by the name of Gina Austin. She's worth a call on this, I think. I'm not sure it's something she'd take on, but she'd be a good ally.
All right. Do we have any other questions from the group? Okay, well, thank you everybody for your participation and for showing up. We are going to make available a more robust version of this slideshow with some citations, which we will get those out to everybody who signed up by the end of this week, and we will have we'll post this to the website later this week as well. So thank you, Mike, for
Yeah, thanks both of you guys. It's great.
all right. And if there are any questions, feel free to well, that's contact me. Don't contact Mike because that's not a real email.
Oh.
But
Oh, no, no, sorry, I thought that was coming from my Zoom. I put my cell number in the chat too. If anybody wants to discuss, you know, some of the political aspects of this or the advocacy history of it, please feel free to give me a call.
all right. Well, thank you, everybody.